Good evening to all. We are about to start the fifth session of our continuing legal education program, the Learn from the Masters, which we had commenced from the starting of this year. For fifth session, today we have Honorable Justice Bechu Kurian Thomas along with us. I invite Justice Bechu Kurian Thomas and our President along with our Secretary to the dais. I invite our Secretary, Advocate K. Anand, to welcome the gathering.
Good evening, friends. Honorable Mr. Justice Bechu Kurian Thomas, President of the Association, Sri Rajesh Vijayan, Senior Advocates, our Committee Member Advocate Sri Vinod Kumar, other committee members, and dear friends. Today's topic being presented as a part of our continuing legal education program is Marching Ahead as a Lawyer. When we decided to choose a person to speak on the topic, we fixed some criteria for setting the speaker, and we started searching for speakers who satisfies those criteria. So comes to the question why we specifically chose Honorable Justice Bechu Kurian Thomas to speak on this topic. The reason are, as a law student, Justice Bechu Kurian Thomas completed his law degree from the Government Law College, Ernakulam in the year 1992 with first rank in the university and was awarded with Annama Kunjako Memorial Gold Medal. As a lawyer, Justice Bechu Kurian Thomas commenced his legal practice in the year 1992 at Kottayam under Advocate P.V. Thomas, and after 3 years of lower court practice, he shifted his practice to the High Court of Kerala at Ernakulam. He took a break after 5 years of practice and decided to go abroad for his higher studies. He was awarded British Chevening Scholarship and underwent study in English Commercial Law and Practice at the College of Law, York. Even when he had several opportunities abroad, he decided to come back to India and establish the firm Bechu Kurian & Co., now BK & Co., in the year 1998. He had extensive practice in all fields of law. He was designated as a senior advocate by the High Court of Kerala in the year 2015, and in the year 2020, he was elevated as a judge of this Honorable Court. As you all know, as a judge, he has authored several notable judgments. Along with his lawyer life, Justice Bechu Kurian Thomas, as a lawyer, never limited himself to his office and litigation practice. He was elected as the executive committee member of Kerala High Court Advocate Association in the year 1998 and was active in all association-related activities for a long period. His deep interest in sports and arts and also his passion for traveling and scuba diving is known to most of us present here. I have also heard from many people that he is a complete family man. The success of Justice Bechu Kurian Thomas is in his career as a lawyer, and his ability to balance his career along with his family and other activities made us choose Justice Bechu Kurian Thomas to speak on this topic, Marching Ahead as Lawyers. Now, may I wholeheartedly welcome Honorable Justice Bechu Kurian Thomas to this function. I welcome our President Sri Rajesh Vijayan and our committee member Advocate C.Y. Vinod Kumar to this function. I welcome all other lawyer friends and law students to this function. Sit back and enjoy the class of Honorable Justice Bechu Kurian Thomas. Thank you.
Thank you, Anand, for that wonderful introduction. I really feel honored on hearing those words. For a moment I wondered whether it was myself. Anyway, thank you for those nice words. My dear friends in this profession, it was with a tinge of trepidation that I accepted this request to speak to you all. Mainly because I was told that 2 years back I had taken a session online and they wanted me to repeat it. Repeating something is very difficult. You can do something for the first time, but to repeat the same is very difficult. I'll try to repeat the same thing to a large extent, but occasionally I may depart from it. Speaking to the members of the bar, of which I was and I am still a part, generates great deal of happiness and joy to every lawyer or every judge. When we see lawyers sitting in front of us, we feel young at heart. We feel young at heart and also would start envying you because you really have the better time of your lives. And here, beyond the bench, life is always books and four walls. The life of a lawyer is full of vigor, joy, and passion. So, when we get an opportunity to speak, mingle, and interact with you youngsters, I'll call even a 60-year-old lawyer as a youngster because a lawyer is always young at heart. I would say it is an opportunity that we will never forsake. From the Shakespearean "Let's kill all the lawyers" to the American anecdote of if you find a lawyer and a snake, kill the lawyer first, worry about the snake later. The lawyers have been a fraternity which was looked upon with disdain and hatred. But times have changed. I'll just add one more thing. In our younger days, we've heard stories about law colleges standing on the roadside, law college management or persons in control standing on the roadside, inviting passers-by to join the law college. These are stories. In the matrimonial market, lawyers had no value, both for men and women. But times have changed. With the education sector in law being very, very demanding, the number of law colleges mushrooming, and the number of law students joining the course, one can only look at it with envy that a profession has changed. A profession has changed to the better, certainly. The kind of arguments that we now witness, or rather I now listen to, I'm really surprised that even a lawyer of 2 months standing is able to stand on his leg and confidently argue, which is a which provides for a great future for the profession. I find that lawyers in the matrimonial market have increased their value with the Tinder, the Hinge, and other applications that are available. The partners who are searching for their soulmates do not shy away from another person merely on the ground of the other person being a lawyer. So I find the value has increased. But why? Have you ever thought that why this value of the profession has increased over the years? I would say it is all because of the industry and hard work of our predecessors in this profession. They have created a solid foundation for all of us to take it to the next level. I said all of us, and because I still consider myself as part of the legal profession, as a lawyer too. We have to take this profession to the next level. How do we do this? What is it that we must do to achieve or to give to our next generation the nobility with which our predecessors have carried on this profession in the yesteryears? It is our duty to hand over the nobility of this profession to our next generation. For this, I have syntaxed. Syntaxing is something which I used to do when I was a student of law. For everything that I study, I'll create syntaxing words. Syntax is a combination of words so that you don't forget things. Sorry. So, I thought about what should be syntaxed. A garment is something people wear, which we call it as an apron. An apron is worn to protect the inner garments. So this profession needs something as a protective cover for all of us. Remember the word apron. A, I'll term it as standing for attach. P for patience. R for respect. O for originality. And N for being natural. I'll just explain these things. As a lawyer, when you step into this profession, or as you continue in your professional life, if you can always be wary of these words, it can help you in good stead. As a youngster, attach yourself always to a senior. What is the difference? One classic illustration is given by Falias Nadiman in his famous book, Before Memory Fades, where you might have all read that when you speak about a racehorse, the first thing that one asks is, from which stable? Similarly, when you see a successful lawyer or a lawyer who's doing reasonably well, the first question your peers would be asking is, from which office? So your office assumes importance. It is your office which can provide you with the traditions of the profession. Our profession, whatever said and done, our profession has got a lot of traditions in us. It is those traditions that have built nobility into this profession. It is a tradition. The dress is a part of a tradition. These noble things come out of attaching yourself with a senior. Of late, there is a tendency for youngsters. We can't certainly question the brilliance and the intelligence of the youngsters because they're far more intelligent than one could even imagine. I'm honestly saying far more intelligent than one could even imagine. But it is not just intelligence that matters in a court of law. I will come to that at a later point of time. There are various other things. And what are the other things? There are 4 stages in a lawyer's life. You might have read about this or heard about this. 4 stages. What are those 4 stages? No case, no fees. No case, no fees, some case. Some case and some fees. And 4th, no case, only fees. Honestly, if you look at the lawyer's career, this is a career graph. No case, no fees. When is that time? That is the initial few years of your profession. If you attach yourself to a senior, the senior has a lot of cases. You would be able to, even if you're not able to argue the cases, you can learn from the senior's case bundles. You can learn the basics of the profession from those case bundles. You would at least get an opportunity to appear before a court, to sit inside a court of law, be acclimatized, be familiar. And what happens when you're familiar? When you're familiar with something, it creates confidence in you. One example is before I came into this, or before I came from my chamber, my heart was beating. Why? Because I was apprehensive of this lecture, even though I used to use my tongue as I've been using my tongue as my daily earning machine. But still, today I was a bit apprehensive. But the moment I stepped in, I realized I am in familiar turf. I've been inside this hall, except for this, before this modifications were done. I was always inside. There were a lot of familiar faces before me. So familiarity creates or instills confidence in one. If you continue attaching yourself with a senior, comes to court, sit inside a court, even if you don't have a case, it creates a familiarity. And when you get an opportunity to argue, there would be a familiar court hall, there would be a familiar judge in front of you, there would be familiar staff in front of you, familiar peers around you. Your confidence level could increase. Attach yourself with a senior. The senior, in turn, must be able to impart the necessary guidance to the youngster who steps into the profession. We keep blaming the juniors. They're not dressing properly. They are not behaving properly inside the court. Whose responsibility is it? When we were kids, our parents taught us the manners. Respect another man, another person. It's a manner that we have to cultivate in us. It is a duty of a senior in an office to impart the traditions of this profession to the youngsters who join their office. We can't just blame the youngsters who come into the profession, but it is a duty of the seniors also to impart that training. Similarly, chamber conveys the principles of hierarchy in the profession. This principle of hierarchy in the profession, I may put it into the third category called respect. So once you attach yourself, then what happens as a junior? You sit there, you stepped into this profession. I remember my life as a junior. I came into the profession with full of vigor and energy. As one of my friends used to say, full of dopamine, always bubbling with energy. But alas, first month, nothing. I couldn't even understand. Asal 14 bar 86 എന്താന്ന് പോലും മനസ്സിലാകില്ല. Can't even follow what the bench clerk was shouting or was calling out. It was so difficult to understand. You feel disheartened, disillusioned, demotivated. That is where patience, I would term the second term, second term, patience. Patience comes in. Patience is a virtue that we must cultivate. With 4Gs and 5Gs coming in, there is no patience for us. We can't even wait. We can't even wait for 2 seconds for the net connectivity. I've been calculating with paperless filing, e-filing, I have to wait 10 seconds to get the case file opened in front of me. I don't have the patience to wait for that 10 seconds. And I said, I want physical file in my hand. Why? I can't wait for the 10 seconds. If I had been able to cultivate that patience in me, I would have been able to easily switch over to the paperless filing, e-filing. So patience is a virtue that one must cultivate in this profession, because no one is going to give you case on the first day or on the second day. But be patient and generate your reading habits and put an investment into this profession. This patient waiting in the initial years is an investment of this profession. There is practically no capital investment in a lawyer's profession in the early years. The only investment was the patient waiting. So invest during this time. If you lose patience, you lose the battle. The third is, so we have attached patience, and the third is respect. Respect your profession, and the profession will start respecting you. Hard work, erudition, and gentlemanly behavior is a must for this profession. Your behavior to your peers and to your seniors will mark what you will be later. I remember when I stepped into the Kottayam Bar Association, the manner in which the seniors were respected, it was wonderful and amazing. What I saw over there, I tried to maintain till I was elevated, and even thereafter I tried to. That is a respect to the seniors in the profession, respect to your peers in the profession, respect to a junior in the profession. You might be the best lawyer, you might be the average lawyer, you might be the worst lawyer, but respect the other person and the other person will respect you. We've also seen lawyers wearing robes on the road with the band and the gown, getting into the restaurants here. It is disrespect being shown to the profession. The moment you step out of the court building, remove your dress, the robes, and don't go out with it, because that shows disrespect to the profession. It is something which we have to impart to the juniors. Give space to the seniors in a court hall. Of late, it is a vanishing act now. The juniors feel that they are more intelligent. Certainly they are. Better equipped. Certainly they are. Why should I give space to my senior? To that senior. It is not so. It is a respect being shown to the profession, to the seniors in the profession. Real power comes by respecting others of the same profession. The fourth one is be original. Be original and develop original thinking in the early years itself. The early years, as I mentioned, is a period of struggle. A comfort zone never creates a struggle. If you are comfortable, there is no struggle. The yesteryears lawyers were always struggling in the initial years. That was a time they created creativity in the profession. That creativity has led to the various judgments that have been rendered by the Supreme Court, the High Court and the lower courts. Short of creativity, we will only follow paths that have already been tread by others. So be creative in the initial years itself and be original. This originality will bring in the creativity required. Natural. I've seen some lawyers who come from Supreme Court while arguing, they'll just stand up on their toes. It is an imitation of what is being done by some lawyers in the Supreme Court. It creates a critical thinking in others who are watching. If you create your own natural style, and the initial years are very important for creating a natural style. No one will criticize you, no one will blame you for creating a natural style in your profession. So in the initial years, when you should be wearing an apron to protect yourself, remember that attach yourself to a senior, be patient in the profession, respect your peers, your profession and your seniors, be original in your thinking and be natural in the style of arguing. With this, we step into the next phase of our profession when we start getting cases. There is as I said, a patient waiting. In that patient waiting, people worry about whether we will get cases. Suddenly comes one case. It could be a 279, 337 matter. We're pleading guilty. Fine, we just need to pay a fine. Or it could be a rent control petition or a bail application. I still remember my first case was a bail application. I had prepared, I think, 2 or 3 pages of notes. I don't know whether the judge would have felt so funny with this 2 or 3 pages of notes for a bail application. But I did not know what to do. But I realized one thing. Read, R-E-A-D, is a very important thing in the profession. In read is a syntax for one R is read, E is engineer, third is advocacy, and fourth is drafting. I've just changed the drafting into the last so that I can create the syntaxing. I just explain these things. Reading, the initial years of your life, the middle years of your profession, and the last years of your profession, continue to read. A lawyer who comes to court without reading can easily be identified because he becomes blunt. I remember one of the best lawyers in our bar being once told by a judge that of late you have become blunt in your arguments. Immediately came the retort, sir, I have not been reading. Read, not just law journals. I know you're all confined to, most of us are confined to law journals. It is not just the law journals. Ideas come into us even from other books. Others' ideas, the authors, the poets, everyone read a lot of books and come up with their own ideas. These ideas can transform into this legal profession as a creative thinking, as next generation's law to be laid down. One of the finest lawyers I have heard from this bar, and I'd say even from any other place, is our own M.N. Submaran Nair sir. I still remember my first and only visit to a court in my final year of law. It was my court visit. I stepped into a court in the Ernakulam district court. I think it was subcourt 2 or subcourt 3. Small room, lawyer. I could not identify his senior court then. What he was arguing is, during childbirth, the mother and the child are traveling to the valley of the shadow of death. One step to the right, both lives. One step to the left, both may die, or one of them may die. Remember, imagine this sentence. I still remember after 30 years or 31 years, I still remember. Why? Because of the manner in which he argued, the erudition, the preparation that he has done. Every word was chosen with so much care. Do we find that? We need to bring that back into the profession. It requires reading from the textbooks, Kathiar on easements, Mulla on contracts, Nelson on injunctions, Crawford, Grice on statutes. These textbooks, buy and keep these textbooks in your library. From the first day onwards, if you can invest into these books, on the textbooks, I would say it will help you in your future more than reading the law journals. These fundamentals give you the basic on which you can spring up in the profession. And even after getting elevated, I realized that time for me to go back into the fundamentals of the profession, and I went and bought Salmon on jurisprudence. In college days, we could not understand anything. It was all Latin and Greek. But now when we read, we start identifying, yes, Salmon on jurisprudence, this is what he meant. So at any point of time in your profession, be it your junior, be it your middle age, be it an old lawyer, these textbooks will help you climb up in the profession. Nani Palkiwala, a man of amazing skills as an orator. If you have listened to his speeches, it is unbelievable the kind of knowledge that he possesses. He is a man who used to read books under a lamppost. The kind of books he has read on economics, finance, anything, he reads. So along with your textbooks and your law journals, read other books also. Preferably, and more especially, poetry. Poetry, if we can read poetry, it will be really worthwhile, because a poet really imagines and comes up with ideas. We do have poetry being written into judgments also now. We enjoy most of those poetry. Second is, in the read, E, is an engineer. What does an engineer got to do with law? I would say engineering has got a lot to do with law. Who is an engineer? Engineer is a person who solves problems. Who are we, lawyers? We are also ones who solve problems. Engineers use their creativity to solve the problems. We must be able to use our creativity to solve the problems that come before us. So be an engineer in your life. Throughout your professional life, be an engineer. A lawyer can be and must be an engineer to solve the problems that come before us. The third is advocacy. There's one wonderful subject that I would like to refer to. Advocacy. 90% of the cases are won by the cases themselves. 10% of the cases alone are won by the lawyers. Of which, what must be your lookout not to win cases by not to lose cases by your demerit? I remember one of the cases I was arguing in the 7th court, that was in the old building. We had practically lost the case. I don't want to name the judges. Division bench was there. However much we tried, we were losing the case. He was about to allow the writ appeal. Suddenly we saw the judge, one of the senior judges, trying to do something with his collar. After 2-3 minutes, he realized that it was about 3 o'clock or 3:30. He realized that he had to rise, and he said, "We'll continue tomorrow." Me and another colleague lawyer said, "We are saved for the day. Anyway, tomorrow is going to dismiss the case." We didn't prepare at all. Next day, we come in. The judge had gone through the files and prepared by himself and came out and said and told the appellant that I'm dismissing the appeal, nothing more. We didn't even have to argue the matter. Whose merit is this? There are cases that are won by itself, but in cases, the 10% of the cases where a lawyer matters, I would say that a lot will depend upon your advocacy. Advocacy is not about arguing things. We had one very brilliant judge, who was a brilliant lawyer in his younger days until he was elevated, who has said that in the initial 6 months of his profession, he was told never to argue a case. He was told, go and sit in every court for 1 week. First week, sit in one court, next week, go to another court. Sit there, see the judge, understand the judge, learn the judge. This is advocacy. Learn the judge. Understanding the judge is a great advocacy, part of advocacy. There are times when we change our drafting in the high courts depending upon the judge who sits in the jurisdiction. If there is a jurisdiction change, there have been times when we have changed the drafting. This is advocacy. Some judges like aggressive lawyers. Some judges like meek and subdued lawyers. Some judges like intelligent lawyers. Some judges like lawyers who don't say anything. Identify the judge. This is your advocacy. If you're able to identify the judge, you may be able to win the case, win the day. And many a times, cases are won without even uttering a word. I have seen with my own eyes in this court, when judgments, orders received by a lawyer have been lost, have been immediately directly struck off because the lawyer continued to argue further. Several times, if you argue slightly further, even after getting an order, the judge may not like it. Right or wrong, but it is your advocacy that you must develop. It is part of advocacy to create a situation of good cross-examination. How do you cross-examine? I'm sure that the real thrill of cross-examination is no longer there, because most of the cases chief examination is by proof evident. The beauty of cross-examination, those of you who have stood on the witness box will realize. I was once examined as a advocate commissioner in my initial years, I was really shaking in my legs. I knew, I went, saw there, I put it in writing, I've written it. I wanted to say everything correctly. I did not want to make a mistake. That feeling, that emotion of not making a mistake itself creates mistake. This is where a good cross-examining lawyer can come up with a destruction of that witness. I will tell you one example. It was one of the famous cases. I'll say the case. Mary Roy versus State of Kerala. This is an important case in 1986 decided by the Supreme Court, where Christian women were given equal entitlement in the paternal share, paternal property. Based on that, a case was filed in Kottayam district, Kottayam sub-court, claiming shares in the property. The cross-examination of one of the witnesses, I was listening intently to my senior, who was great, was known for his art of cross-examination. The way he went ahead with the cross-examination, noticing the character and nature of the witness, he put in certain questions which really propelled the ego of the witness. Soon, the witness started blurting out things contrary to their own case. He stopped, he knew where to stop. He stopped it and sat back. At the argument, nobody ever realized what was going to happen. At the arguments, he just came up with a point which was so startling that they lost the case. Law was on their side, facts were on their side, but the witness blurted something which was contrary to their case. This is the art of cross-examination. It is a dying art. It is time that we revived it. You lawyers revived it. How do you revive it? Don't learn, don't prepare the questions for the cross-examination. It is a fundamental thing. Never ever prepare the questions for the cross-examination. Prepare only the answers for the cross-examination. If you have the answers prepared, you may ask 10 questions. Ultimately, what you want, your objective is to get this particular answer. But if you have only questions prepared, you ask the question and answer comes, which is contrary to your liking, contrary to what you want, that will be the end of it. That will be the end of your questioning. You will then shift to the other point. You will leave that point spoken by him against your case uncross-examined. So prepare only the answers. The advocacy part, I would say one more thing before I conclude, before I move on to the last. That is, think about a case more than even reading a law journal. I've heard a senior advocate, Narayanan Poti sir, referring to this aspect. He thinks about the case when he goes for the morning walk. If you realize, if you practice this, when you sit at home or sit in the office, close your bundle, close your file. Just think about the case. The number of points that comes to your mind is unbelievable. This is where your textbook reading, your creativity, your originality, everything comes in, where your mind starts working with all the influences from the perceptions that you've had in life, your experiences in life, your knowledge, what you've heard in court, all will come into play and your mind will start working. You think about it something for more number of minutes or more number of hours, this problem or the solution itself will be solved by that. You will get answers. So, while preparing your arguments, your cross-examination, think about the case. Think, think, think. The last is drafting. When you draft, as a judge, I came across 6 pages of synopsis in one case and 5 pages of statement of facts, grounds and reliefs. The additional 1 page is points, dates and events, all these things. It is practically the same thing as a statement of facts which People draft into the synopsis. No. Why is the synopsis provided? Judges invariably don't have time to go through all your files. If you've got a good point, if you've got a good case, that must be there at the first point. What does a judge do? This is what I've thought. As a lawyer, this is what I used to do. I have told this to my associates also. Always, the first paragraph could be looked upon by the judge, could be read by the judge. Put your thrust into the first paragraph. This is my case. This is my point. I call it a triangular way of drafting. This is what I always used to do. I don't know whether they are still following it, but this is what I used to do. Every repetition, every case of mine, whether it is civil appeal or the first point will be practically the main thrust of the case. From there, we go down, we develop, and then it goes. So it's a triangular form of drafting where the point is at the beginning and the base will come to the point. It is a style which you can evolve. This is just my style I evolved. You can evolve your own style. But remember, what you want is the judge must understand the case. Whatever you draft, however judgments, however pleadings you draft, it's not possible for judges to go through all this. What you want, highlight it, make it easily understandable by the judge. And also, while drafting, preferable that you weave your case like a story. If you can weave your case like a story, it will be very interesting for the judge to read. It will be very interesting for the opposite lawyer also to read. In this context, I would say that there is a tendency for all of us to enter into a diarrhea of case laws. The diarrhea of case laws actually retards your original thinking. Try to avoid the diarrhea of case laws. If the judge asks for you, supply or support your arguments with case laws, not from 1920s to the 2020 or 22s. It is not what is required. Answer promptly. Whenever a question is put to you, answer promptly. The judge wants, whatever you're arguing, give the judge what he wants. Ultimately, you are paid to win over the judge, not to quarrel with the judge. Never ever quarrel with the judge. If the judge puts in a very foolish question, don't try to tell him that you are very foolish. Tell him, yes, that is a brilliant question. I'll give you one example. 11 judges bench of the Supreme Court was hearing an important matter on minorities' rights in the Supreme Court. 10 days or 11 days of arguments. The arguing lawyer was Nariman, Father Nariman. One of the judges put a question. It was like after reading Ramayana asking who is Sita. A question similar to that. All the 10 judges were wonderstruck. They wanted to help the judge. They feared what retort was going to come from the arguing counsel. But this is what happened. The counsel said, "My lord, for several days and weeks I have been studying this case threadbare. Till now, this point never crossed my mind. May I be given some time to ponder over this question during the lunch recess, and I'll get back to your lordship." He never got back with the answer. The entire remaining 10 judges came completely on his side, because that case never ended in a decision because that bench was dissolved. But on that day, the advocacy won the moment and the day for the lawyer. So this is what we must try to develop. Don't try to crack jokes in court, but you can be humorous. But don't try to crack jokes, especially to judges who don't like humor. I know when a judge cracks a joke which is not at all humorous, most of the lawyers tend to smile and laugh. We understand, as judges, we understand all this. In our heart of hearts, we will also be laughing with you at what a foolish joke or humor that we have cracked. But these are all part of the fun and thrill of this profession. Overall, I will tell you, this is one profession where there is not a moment of monotony in our life. Every moment we are active, we are vibrant, moving around, studying different cases, solving problems, and meeting the number of lawyers you meet every day. I was telling somebody, I think it was Justice Gopinath, during the annual day, this is one sphere of a profession, a sphere of an activity, an establishment, where there will not be anybody to compete with us with the sheer number of people who are coming together at the same time every day. No other profession can boast or command such numbers coming together every day. 8,000, 7,000, or even 5,000 every day, or 3,000 every day. This huge numbers is certainly a great fillip for our profession, a fillip for our day. I wish all of you a great future in this profession. Let our profession fly high, and as judges, or as a judge, I'll speak for Gopi also, and Shobha also. As judges, three of us, being on this side till recently, and have come over here, we really miss the activities of the profession as lawyers of the Kerala High Court. I am sure that you will continue to invite us to be part of your activities. Thank you very much.
Thank you, sir. Thank you for the wonderful session. Now, if any of you have any questions, queries to ask, you may please come forward. I think everyone is content with the lecture. So now I invite our president to express a token of gratitude as part of the association, from the association, to Honorable Justice Bechu Kurian, sir. Sir, please. Now I invite Advocate C.V. Vinod Kumar, our Executive Committee member, to propose the vote of thanks.
Good evening all. I deem it a great honor to propose the vote of thanks on this continuing legal education program conducted by the Kerala High Court Advocate Association. I would like to propose my gratitude to Hon'ble Mr. Justice Bechu Kurian, sir, for gracing this occasion with his wonderful lecture and sharing his experience in profession. Thank you, sir, for the interesting class. I also thank the Honorable Judges present here, and thanks to all of you for making this event a successful. Thank you.